Wagwan. Good morning, good night, welcome back. And if you're listening for the first time, welcome to episode 14 of The Real Situation, where we give you a taste of Jamaican politics. I'm your host, Melanie Byfield, and in this series, we're focusing on Jamaica's journey to becoming a republic. Just as a reminder of where we are, in 2022, the journey to full independence restarted. Why now? Why not? 'Cause obviously the journey not done. Jamaica's head of state is an English king. Jamaica's constitution, which represents the highest law of the country, is a colonial document called the Second Schedule of the Jamaica Constitution Order in Council 1962, and unofficially third, Jamaica's highest court and final court of appeal is the Privy Council in London. I say unofficially because this is the first of three phases of the constitutional reform. Right now we're in the midst of phase one, but the final court of appeal is not included in it and is actually a source of contention. So yeah, we're in phase one, focusing on changes to the deeply entrenched provisions of the Constitution, which involves removing King Charles as head of state and replacing him with a Jamaican head of state, which would then transform Jamaica from a constitutional monarchy to a constitutional republic. It also involves amending the present constitution into a constitution of Jamaica by the people, of the people, and for the people. Since the proposed amendments are deeply entrenched, the Constitution requires a referendum be held so that the citizens of Jamaica who are entitled to vote say either yes or no to a bill that contains those proposed amendments, which has to pass 2/3 majority in both houses. And it's going to need consensus because the government doesn't have 2/3 majority in the Senate. As I said, before, some might say that to-do list for this phase isn't complete because the CCJ is missing. When the 15-member Constitutional Reform Committee submitted a report of recommendations in May 2024, which was tabled in Parliament as a ministry paper, Mark Golding took issue with several matters that concerned the opposition PNP and other people, I might say, including, things like the appointment of a president, the fact that an impeachment provision was omitted, right? Just to name a couple. But the biggest contention that the PNP have relates to Jamaica's final court of appeal. The argument being that Jamaica won't be fully colonized, won't be fully decolonized, while keeping the Privy Council in London, and the Caribbean Court of Justice needs to be in its place. So let's stay on the subject of the CCJ for a minute. In the Jamaica Gleaner on October 27, there was an article called Siaga's Defining Charge to Wholeness. In this article, it underscores that Andrew Holness stands alone on this sensitive issue along the decolonization journey and that he needs to move into the fold to join hands with his visionary predecessors speedily. What does that mean? Edward Siaga was a member of the 1970 Hugh Shearer-led cabinet that gave birth to the groundbreaking policy decision that Jamaica would embrace a regional final court in substitution for the Privy Council. At that historic juncture, both Shearer and Siaga were of one mind. Months before the court's inauguration in 2005, when the Privy Council declared that the procedure for Jamaica to make the transition was by a 2/3 majority vote in each house, Siaga withdrew. So, while the government's position is still unclear, the opposition actually stood firm. And during a diaspora town hall meeting in Canada on October 30, Mark Golding confirmed that the PNP are committed to constitutional reform, and as a nation, Jamaica needs to be fully sovereign. He went on to say that the CCJ is serving our regional partners, and that right now as a Jamaican, you can't afford to take a case to the Privy Council. The CCJ was established to make the procedure more user-friendly. The court can come to Jamaica to hear cases, and it has done so in the past. But for some reason, Mr. Seaga switched and decided that the court should be free from political interference. So, as a result of that, extra care was given in the design of the court and its own funding through a trust fund that was established from the start, so no budget of any country was needed in its operations. Mr. Golden added, it is an excellent court doing excellent judicial work, providing access to justice at the highest level. What does that highest level look like? Well, on October 29th, the swearing-in ceremony took place of Justice Chantal Ononayu, a newly appointed judge of the CCJ, that took place in King's House, Jamaica. Why King's House, Jamaica? Well, Justice Ononayu is a born Jamaican and specifically requested this location for her swearing-in, where she gave not only homage to Jamaica as her place of birth, but where she was educated. On a side note, Dr. Ononayu is a Rhodes Scholar. She has a Doctor of Philosophy in law from the University of Oxford. She has a Master's of Law from the University of Cambridge and a Bachelor's of Law with first-class honours from the University of West Indies, as well as a Legal Education Certificate of Merit from the Norman Manley Law School. And at the start of her legal career, Dr. Ononayu worked as counsel in the Constitutional and Legislative Affairs Division of the Attorney General's Chambers in Jamaica. Dr. Ononayu is an attorney at law with over 20 years' experience. In particular, she specialises in, she's of specialist expertise in Caribbean community law and international law, including international trade law, which was actually a requisite for that appointment. During the recruitment process, the Regional Judicial and Legal Services Commission, which is the independent body that is responsible for recruiting staff and judges for the CCJ, received a whole bunch of applications. They had applications from the Bahamas, from Great Britain, from Canada, Nigeria, Dominica, Jamaica, Sri Lanka, Suriname, and Trinidad and Tobago. Of those applications that were received, 4 candidates, 3 female and 1 male, were shortlisted. And who was the successful candidate? Dr. Chantal Ononayu. Now, the government's position on a final court of appeal still hasn't been made, right? But let's look at what else is being proposed that we know their position on. So we're going to go to the CRC's report, and we're going specifically in this episode to Section 6, which is the reform of the Parliament. So we're going to look at a couple of subsections within that. So let's start with, we're going to do it out of order, right? So 6.2 looks at disqualification. Disqualification from sitting as a lawmaker. So basically what this section is that the CRC is strongly of a view that a person who is convicted of a serious criminal offence should be disqualified from sitting as a lawmaker. The Constitution currently provides that a person who has a criminal record is not disqualified unless the conviction is for an electoral offence. Here's what the CRC are recommending. They recommend that there be a provision that this is expanded, and there'd be a provision to include convictions for offences involving treason, an offence involving fraud or violence, where the person has been sentenced to a term of imprisonment for a period of 18 months or more. So now they're looking to include crimes like murder, manslaughter, rape, robbery, aggravated assault, which are all classed as violent crimes, and also money laundering, government fraud, charity fraud, and Ponzi schemes. What are your thoughts on that? Do you think that goes far enough? And why not have this in place for people who are currently serving, right? Not just not just disqualifying you from being, from sitting in Parliament, but it should eject you out of Parliament too. What are your thoughts on that? So this brings us to actually a next section, which is 6.3, which talks about the impeachment process, which would be punishment for parliamentarians for sitting parliamentarians, right? But one that the CRC feels there should be no inclusion of. Now, we talked about this before, and there was a very strong pushback on the omission of this impeachment provision. If you recall, Bruce Golding, former JLP leader and Prime Minister between 2007 and 2011, respectfully disagreed with that provision. And actually, he viewed it with dismay. He went on to confirm that impeachment had been agreed back in 1995, and it was part of the JLP manifesto in 2007 and 2011. And Bruce Golding actually drafted an impeachment bill, which was then tweaked by Mark Golding and tabled in Parliament. It was called the Constitution Amendment Impeachment Act. It was tabled in April 2021, and it's still dead upon the table. It's not gone away. Basically what Mr. Golding said is you can have a public official who misconducts himself or herself in a particular way, but it's not a crime. But you certainly don't want that person continuing in public office. The last update in this respect, Ms. Malif, Fort, said the deliberations were continuing regarding the inclusion of impeachment provisions for MPs and other officials. So let's move to a next part of that section, which is 6.1, the citizenship qualification. It is referenced in section 39 of the Constitution. And basically the CRC considered whether, what the citizenship criteria should be for members of Parliament in Jamaica. Now, there were some specific questions that were addressed here, right? Whether the entitlement of the Commonwealth should remain, whether citizenship of another foreign country should be barred, the type of citizenship qualification, and whether Commonwealth citizens who are not Jamaicans should continue to qualify for membership in the Parliament. And basically what they said is that the Commonwealth citizenship language should be removed. Not a problem with that. So the real, issue of any real consequence, right? What we really care about is the Jamaican citizenship. And what the CRC said is that Jamaican citizenship should be the essential qualifying criteria to be a member of Parliament. So let's move into that a little bit further, because on May 20th in the Gleaner, there was an article entitled "Goldin Still a British Citizen," and he basically said, my view is that the better approach is for all Jamaican citizens to be eligible to sit in Parliament if they wish to serve, including Jamaicans who are dual citizens from non-Commonwealth countries. So how do you become a citizen of Jamaica in the first place? Well, it's either by birth, descent, or marriage. But we're going to focus a little more on the birth and descent aspect, because it then does invoke this conversation, right, about dual citizenship, since the Commonwealth element has now been removed, right? Or that's the intention, anyway. We have a Jamaican diaspora that's actually higher in number than the population of Jamaica itself, right? There are first, second, third, fourth, and fifth generations of Jamaicans outside Jamaica. Born Jamaicans have travelled out and live in countries where they have children. They have grandchildren and great-grandchildren. Generations of Jamaicans who by descent are automatically entitled to Jamaican citizenship and eligible to sit in the Parliament. There's also a number of Jamaicans who live in Jamaica, but they're not born in Jamaica, or whose children weren't born in Jamaica. So the idea of excluding a parliamentarian based on dual citizenship, that's a difficult one, right? When there's generations of Jamaicans by descent who are eligible to sit in Parliament. So what effect would that have on a couple of these scenarios, right? So there was the Dadoob versus Vars case, right? And it raises the question, should you really have to renounce if you acquire citizenship by descent, right? His mother was born in Puerto Rico, his father Jamaican. But right now, under the Constitution as it is right now, he had to renounce that US citizenship because it only permits dual citizenship within Commonwealth countries, and the United States is not a Commonwealth country. So these proposals would shift that, right? We have other cases where, for example, in The Observer on June 30th, Julian Robinson says he will renounce his UK citizenship. I mean, he didn't have to. Under the law, he was entitled to keep it. Dude was born in the UK while his father was pursuing a master's degree in law, right? And it states that his family returned to Jamaica before he was a year old. If you are born in another country and you are of Jamaican descent, do you have to renounce that citizenship? Let me know what you think about that. On May 30th, Radio Jamaica News reported that Matthew Samuda says he's renouncing his British citizenship. And again, you have someone who was born in London. He says, I am indeed a dual citizenship. I was born in London. That's not a secret, right? But he was in the advanced stages of renouncing his British citizenship. Why? Again, I mean, do you think that's necessary? I mean, there can be protections that could be put in place to make sure it's not being abused. And then you could ask the question, should there be a distinction between, citizenship by birth and descent, different from acquiring a passport as an adult, right? Or acquiring citizenship from another country where you enter as an immigrant. The US, there was a bill proposed, HR 7484, called the Dual Citizenship Disclosure Act. It was introduced in the House February 29, 2024. It was a bill, it's called a bill that requires members of Congress who are foreign nationals to file a statement with the appropriate Congressional Ethics Committee describing their status as a foreign national. The Congressional Ethics Committee may fine a member for up to $2,500, right, which is 375,000 Jamaican dollars approximately, for non-compliance. That was a bill that was proposed, right? Bearing in mind that US members of Congress do not have to be born in America, but they are required to be a citizen. In the case of a senator, you have to have been a citizen for 9 years and live in the state that you are going to represent. And examples of, senators who aren't born in America are Tammy Duckworth. She was born in Thailand. Maisie Hirono, she was born in Japan. Right? So, yeah. Still not real clear cut, but yeah. And apparently not everybody agrees. For some, the real question is applicable to those who voluntarily get up, go and live in a country and then acquire citizenship before deciding to relocate to Jamaica and want to sit in Parliament. So, in the Gleaner, there was an article called on January 27, 2011, called Foreign Allegiance versus Dual Citizenship. And in this article, Devon Dick, pastor of Boulevard Baptist Church in St. Andrews, said, "The issue isn't about foreign citizenship, but rather foreign allegiance. That is, a deliberate act to demonstrate allegiance to a foreign power or state. In that case, it's about citizenship not acquired by birth or descent." And also bearing in mind, if you become a citizen in the US under the age of 14, no oath is required. There's also another article, May 21st, in the Gleaner, Golden urged to renounce, and it's by Shoshana Small. She says, but while agreeing with Golden that it is not illegal for him to have British citizenship and serve in the Jamaican Parliament, it's not illegal, right? Political commentator Jermaine Barrett argued that he has a moral responsibility to relinquish his status as a UK citizen, and that the Constitution should be amended to ensure that only people with sole allegiance to Jamaica can serve as the nation's Prime Minister. Now, that's a whole different argument, right? From sitting as a parliamentarian or being Prime Minister, because, I mean, we just talked about how you can be a sitting senator, right? In the US, you don't have to be born there, you have to be a citizen, but to be the president, you have to be born in America, right? So it's two different something there. Political scientist Dr. Paul Ashley is of a similar view. He says, I'm not comfortable with a Prime Minister being of dual nationality, whether it be Commonwealth or non-Commonwealth. Actually, he went even further, and he said that no parliamentarian should possess dual citizenship. There's another article I want to refer to, which is May 24 in the Jamaica Gleaner. It's the letter of the day. It's called Open and Frank Discussion, the Basis for Constitutional Reform by Anthony Hilton. And the article says, the sudden newfangled argument that there should be a special rule that the Prime Minister and the Leader of the Opposition must be Jamaican born to ensure that he or she doesn't have divided loyalties smacks of opportunistic political convenience. In any event, the Prime Minister cannot make up the law as he goes along. The latest furore suggests more panic by the JLP than a reasoned argument. And then we have another article, May 25th, in the Jamaica Gleaner, where Lloyd Barnett says that the CRC, would be willing to deliberate on this topic of dual citizenship. And he goes on to say that citizenship by descent shouldn't disqualify me, but focus on the essentials of that duality and whether or not the person has a conflicting allegiance. And you know what? It is very strange that, given that this is such a hot topic, it wasn't part of what the CRC had in their terms of reference. Go figure. Okay, so what was the Prime Minister and the opposition leaders say on this whole thing? I have two articles that we could look at. On May 22nd, Caribbean Today had an article called Jamaica's Opposition Leader Responds to Prime Minister Holness's Statement on His Dual Citizenship. Holness, the Prime Minister, said, I think it's important. I think in the minds of every Jamaican, the question should be, is the leader of your country fully, wholly and solely committed to your best interest? And there is no other loyalty or interest drawing on the decisions that they make. But Prime Minister Holness said that while he's not against individuals with dual citizenship constituting the Parliament, he believes once the individual aspires to lead Parliament, for them to remain a dual citizenship, a dual citizen is just untenable, but is also incurable. He says, for two things we believe that we must find a way to include our diaspora, our Jamaicans. So once you're Jamaican, you have a Jamaican citizenship. We believe you should be entitled to enter Parliament and serve. However, having entered the Parliament, if it is that you intend to become the ultimate decision maker, then you must divest yourself of any other loyalty, even if it is not legally required. Let me repeat that sentence. However, having entered the Parliament, if it is that you intend to become the ultimate decision maker, then you must divest yourself of any other loyalty, even if it is not legally required. So I'm going to jump, before we hear what Mr. Mark Golding had to say, right? I'm going to jump to an article on June 9 in the Jamaica Gleaner, where it says, Andrew Holness and Mark Golding, Time to Choose Jamaica by Kay Osborne. But the one thing that article pointed out was that 3 years ago, on May 26, 2021, on swearing allegiance to His Majesty's Privy Council, Prime Minister Holness read aloud and signed a solemn and voluntary oath, promising loyalty and service to the monarch, swearing by Almighty God to be a true and faithful servant unto the Queen's, now the King's, Majesty. All right, so now let's move on to what Mr. Golding had to say. He said me and the Prime Minister's proposals are not in the report of the Constitutional Reform Committee and won't be in the new constitution coming out of that process. I'm on Barnia. But the local government elections and recent polls seem to be driving some to grasp at straws. I'm a born Jamaican and have a Jamaican passport. I've never hidden that fact that my father, who came to Jamaica from the UK, had got me a British passport when I was a young child. I'm going to finish up this topic with an article by P. Chin, June 14, 2024, called "Dual Citizens Are Invaluable Assets." And the article says the following: Jamaicans who are born overseas can never change this fact, even if they renounce. With dual citizenship acquired by birth or descent and never had to swear allegiance to another country. Many Jamaicans have lived and worked in other countries and have expertise that could benefit Jamaica tremendously. The critical issues are loyalty and allegiance, which is measured by actions and balanced with competence, integrity, and service. I hope you're continuing to enjoy our journey and that you're finding it educational and useful, and keep looking forward to our continued travels together. Jamaicans are a very talented set of people, and there's plenty of great mechanics to deal with this broke down Porsche that we have. It's going to get fixed, don't worry yourself. You can find this podcast on YouTube, Buzzsprout, Spotify, Podcast Index, Deezer, Podcast Addict, Apple and iHeartRadio, and Amazon Music. If you want to reason about anything that we discussed in this episode or any other episode, or you can't find any of the material I was talking about, you can email me at atasteofja@outlook.com. And until the next time, I really and truly give thanks for your support. And I'm asking that you please share this podcast with friends and family. And again, I thank you for taking the time to listen. One love.